Hi, I'm a former New York State Supreme Court Justice. I'd like to tell you about a real story. Now, this happened in Kentucky. It was a criminal case. Our firm was not involved in this case. The defendant was African American. The prosecutor in that case selected a jury and used his peremptory challenges to exclude all of the black jurors who had been called on that jury panel. The end result was that it was an all-white jury. The defendant in that case was ultimately convicted of a criminal crime. Case went up to the Supreme Court of the United States on the grounds of equal protection, the constitutional violation, that the prosecutor had systematically excluded all black jurors so that he'd be left with an all-white jury. The Supreme Court in that case, called Kentucky versus Batson, reversed the conviction, sent the case back to the trial court for a new trial. Now, our case, it's a civil case. In our case, our client was an African American lady who fell in an office building in a defective floor, we claimed, sustaining a very substantial injury, fracture to the upper thigh, requiring all kinds of surgery and things of that kind. While the jury was being selected, the defense attorney, an insurance defense attorney, actually excluded all of the black jurors who had been called to the panel. When that happened, we immediately went to see the judge. We complained to the judge that actually black jurors had been excluded so that there would be only a white jury remaining to try our African American client. We claimed that under Kelly, Kentucky versus Batson, that applied equally to civil cases. Well, the insurance company lawyer said, oh no, it only applied to criminal cases. We said, Judge, the 14th Amendment Equal Protection Clause is equal, which means it applies to every American in the United States. And there could be no discrimination against anybody on the basis of race, either jurors or anybody else. And it would be a constitutional violation. Well, the judge says, well, there's no such case in the country. We said it should be, this first case should apply. The civil case should be applicable just as the criminal case was applicable as well. Judge thought about it, held a hearing, and he said, you know what? You're absolutely right. The 14th Amendment of the United States Equal Protection Clause is equally applicable to civil cases. And for the first time in the United States of America, a landmark decision was made, and we were involved with that landmark decision. As a matter of fact, the case went to trial with another jury. There were 2 black jurors on the other jury, and the verdict came back on behalf of the plaintiff for an amount that was in 7 figures, and it was the largest verdict of its kind for that kind of an injury. In fact, the case was written up on the front page in a long, long story. The novelty of it, the fact that Kentucky versus Batson, a criminal case that went all the way to the Supreme Court, had been applied for the first time in a civil case, made the front pages of the New York Law Journal and other media throughout the country. And we were proud of the fact that we were very responsible for changing that law and changing the attitude with respect to the 14th Amendment of the United States Constitution. Well, that's the story. And until we meet again, this is the storyteller telling you to stay safe and keep out of danger.